In this case of law between Amadio versus Commercial Bank of Australia, which happens in 1983, it is an example of a bank guarantee case law. Mr. and Mrs. Amadio were elderly Italian immigrants with limited English skills. They have bought the property in Australia with their name onto it. The banker of Commercial Bank of Australia has asked Mr. and Mrs. Amadio to sign a contract, believing that it is limited in scope and time. This is in order to fulfill their son's request, Vincenzo, for his business in exchange with mortgaging their property to Commercial Banks of Australia. Without further detailed information, they signed the contract that has been brought by the banker. As day goes by, Vincenzo's business, unable to cover this debt. He is fully aware that he has tricked his parents into mortgaging their home as the guarantee of his business debt. This means that the Commercial Banks of Australia will enforce the mortgage of his parents' home as the term of the debt. When the banker of Commercial Bank of Australia returned to the couple to inform them regarding the mortgage of their home, they were in complete surprise. The bank, aware of the son's financial difficulties, did not explain the full nature of the guarantee to the Amadios, nor did they have taken the step to ensure they understood the agreement. As this case passed by in the legal proceedings, the issue arises is that whether the guarantee signed by Amadio should be enforceable, given their limited understanding of the contract and also the bank's failure to disclose critical information. The High Court of Australia ruled in the favour of the Amadios, finding that the contract was unconscionable. The court held that the bank took advantage of Amadio's vulnerability, which is their limited English skills, lack of commercial knowledge, and also their full reliance towards their sons. And the bank also had failed to explain the full nature of the transaction. The key provisions that have been taken from the Competition and Consumer Act 2010 from the Australian Consumer Law, which is the first one is Section 20, unconscionable conduct within the meaning of the unwritten law, which refers to unconscionable conduct as understood by the principles developed in common law and equity. Besides that, Section 21, which also refers to unconscionable conduct in connection with goods and services, prohibits unconscionable conduct in connection with supply or acquisitions of goods and services in trade or commerce. The key points that can be taken from this case of Amadios versus CBA to be related to the law of nature is the Unconscionable Conduct Act. Though not explicitly stated in the Contract Act, Malaysian court may have also followed the equitable principles, which is inspired by this case, that address unconscionable conduct. This means that if a person signing the contract does not understand the terms due to language barriers, age, or lack of education, and the other party is aware of this and fails to explain the terms, the court may find the contract unconscionable and refuse to enforce it. Besides that, the bank have also breached the caveat contrahentis principle, which refers to let the contracting party be aware, which highlights the importance of being cautious and fully understanding the obligations and the risks involved when forming a contract. This idea emphasizes that both parties in contractual agreement have a full responsibility to ensure that they are fully informed about the terms, conditions, and potential consequences of the contract.